We have just formed a quorum. This is a meeting of the Bills Committee on Inland Revenue, Amendment number 3, 2015. I thank all the members who have come back to join our meeting. First item, confirmation of minutes. The draft minutes of the meeting held on the 7th of July 2015 have been sent to members. It's paper CB 11169/1415. The Secretary hasn't received any proposed amendments. May I confirm the minutes now, members? Thank you. Next item, meeting with deputations and the administration. Please invite the deputations and the administration to join us. Welcome. Before we proceed, do we have any declaration of interest from members? If not, then I have to declare my interest. For 9 years, I was a member of the Board of Review Inland Revenue. And I'm also an ex-official member of one of the deputations, Joint Liaison Committee on Taxation.
Joint Liaison Committee on Taxation. And in making the representation, Mr. Onesnicki, please be reminded that simultaneous interpretation of the meeting in English is available. And you can use the headphone and listen to channel 2. And also, another issue I would like to remind you, Mr. Onesnicki, is that your presentation and your submission will not be covered by the protection and immunity provided under the Legislative Council Power and Privilege Ordinance. And today we have the civil servants here, and also the thank you very much for taking the time today during this recess session to attend the meeting. Mr. Onesnicki, maybe you can begin your submission, please.
Thank you, Mr. Chairman, members. Look, just to make clear the JLCT's position on this bill, we actually do support most of the provisions. It has 4 distinct elements. The only provision that we do oppose is the provision relating to the leave procedures from the Board of Review to the Court of First Instance. And I'll just make 3 points about that. First, we think that the standard, the reasonable prospect of success standard is too high. It sets too high a bar on the making of appeals from the Board of Reviews, and we feel that that is unfair on taxpayers who will be the ones who will be disadvantaged by this mostly. Just to understand, the current test for an appeal under the current procedure is the taxpayer simply has to show it has an arguable case. The Board of Review has articulated that to say that an appeal will be denied only if the taxpayer's case is plainly and obviously unarguable. But the way this legislation is proposed, the proposed test will actually make a much higher standard. The taxpayer has to demonstrate it has a reasonable prospect of success. That will make it harder to conduct appeals, and on top of that it will also complicate the judicial system, because in making that decision a court will have to spend some time examining the merits of the case to decide if that threshold has been met. So there's the first point. Second point, look, we do understand that there are other appeal procedures in other legislation that have a reasonable prospect of success standard, but they're not applicable in this case, and they shouldn't be. First, if we look at the Labour Tribunal and the Small Claims Tribunal, you simply can't compare that with tax appeals. Labour cases and small claims cases are small cases. Tax appeals can involve large amounts of money. They cover multiple years of assessment. The biggest case I recall involved about $1 billion of taxation. So we're talking about big money here. And it's a case where taxpayers should have a relatively free right of appeal. The other point is when you look at the Lands Tribunal and the Small Claims Tribunal, those cases are decided by judicial officers. They're legally trained, they're lawyers, they're subject to the supervision of the Chief Judge. Border review cases, on the other hand, they're decided by 3 people, 2 of whom are not necessarily legal trained, none of whom have tax expertise. Government policy is that appointments to the Border Review are of people who do not engage in tax practice. So by definition, the background of the Border Review judges is that they are not tax experts. And in that scenario, we need to have to balance that by giving taxpayers a right to take their appeals to a higher level. Likewise, we understand the reasonable prospect of success test applies to appeals from the District Court to the Court of Appeal, but that is an appeal from a judge who is legally trained and expert in what he's deciding. So those cases cannot be compared with Border Review cases, and we believe that there has to be a relatively more flexible right of appeal in those cases. Now, the administration has said that it has consulted with the judiciary on these points. I don't know with whom they've consulted, but certainly what a judicial administrator would regard as important in terms of efficiency is somewhat different from what is fair to taxpayers. Somebody in this debate has to look at this from the perspective of what is right for taxpayers, and that's the capacity in which I'm here today. And the final point I'd like to make is simply this, that let's examine the reason we are here today to review this bill is because the Court of Final Appeal did state in a case a few years ago that the current case-stated procedure has to be reformed. It is anachronistic, said the Court, it creates delays, it takes up time, it increases expenses. And so they said we need a simpler appeal procedure. And we endorse that, of course. But I would just caution that we need to be careful that in this reform process we do not introduce those same hurdles through the back door by imposing a leave process, and one that is complicated and difficult to overcome. And in fact, we are repeating the same problems that exist under the case-stated procedure. We are requiring a separate hearing to obtain the leave, and not only that, we are making the standard, the qualification for appeal, higher than before, and that seems to contradict what the Court of Final Appeal was proposing. So they're my 3 points, but since I have a little bit of time, just one final point, which is more personal observation rather than one made by the JLCT. We do have a tax system in Hong Kong that is very important for the collection of revenue. And for all the number of taxpayers we have in Hong Kong, we have a relatively simple ordinance, and there's a lot of confusion as to how that ordinance actually works and what it says. There are a lot of disputes between the IRD and the taxpaying community. There are many issues of interpretation where there are differences of opinion. These generally don't go to litigation that often. We do not have enough case law in Hong Kong to give guidance to the tax community as to how the Inland Revenue Ordinance should be interpreted on key issues. And because of that, I would suggest we should actually be promoting more tax appeals rather than making it more difficult. And I'll end there, Mr. Chairman. Members, if there are any questions, I'm happy to take them.
Okay, thank you, Mr. Olamsnicki. 以下時間我想俾翻
Now I'd like to invite the government to respond to Mr. Olamsnicki's submission. Deputy Secretary, before I respond, I would like to thank the Chairman for arranging this meeting during the summer recess of LegCo, and that this second meeting has been arranged so quickly. I'm grateful for that. We have prepared this bill after working for so long, and there was some consultation conducted. As the chairman of JLCD said, we want to improve the system so that the Board of Review can handle more tax appeal cases expeditiously. Let me now briefly respond to the 3 points made by the chairman of JLCT and also his personal observations. I note that from the submission of the JLCT or other deputations for that matter, they are looking at the proposed cancellation of the case-stated procedure, and then the appellant can go to the court of first instance to lodge an appeal, and there's a leave requirement. JLCT submission has reservation about this requirement, but I note that the agreement from the Bar Association, the leave requirement procedure is not just applicable to the Board of Review procedure. Other tribunals and or Board of Reviews in other areas are requiring the same procedure. As for the threshold, that should be considered by the appellant court. I have to stress, this point has been touched on by the chairman of the JLCT. Well, we have consulted stakeholders, we have consulted the judiciary through the JA's office. We have also consulted Chief Judge. They make a strong point that in considering whether there should be an appeal allowed, two requirements should be met. First, in respect of the matter under appeal, there is a reasonable chance of success. Second, whether there is anything that would go to the arguments of fairness and justice, then that would be an important consideration in considering whether leave should be granted. In 2009, the judiciary and the government worked together to prepare some civil law reform measures. As a result of that exercise, the relevant appellate procedures of the Lands Tribunal and the district courts similarly involve the consideration of two factors. First, whether there's a reasonable chance of success, and whether there's anything to do with the fairness or justice in the case.
So, when the judiciary considered our bill, it made a very clear and strong request that the law clearly reflects the principle of civil justice, the view of the judiciary, and also the practice by the court in considering application for leave. And secondly, regarding the composition of the Board of Review and its operation, whether its operation is very similar to that of the small claims tribunal or labor tribunal. Of course, each tribunal deals with cases of different nature. However, I cannot agree that the Board of Reviews deals with cases involving a huge amount of money. In fact, for the Lands Tribunal, it deals with huge interests and a great amount of cases involving great amount of money. And therefore, we cannot use that as a basis for consideration. Besides, the composition of the Board of Review, and also the chairman must the one who chairs a hearing must be the chairman or someone nominated by the chairman. And under the current legislation, he must be experienced and knowledgeable in law, and this is already set out in the relevant ordinance. Yes, tax matters are very different, and therefore it is set out in the legislation that the one who chairs a hearing must have legal knowledge, and the other two members must have knowledge on tax matters. They might be from the accounting or the tax sector, and I think these are the main considerations for appointing members. The chairman of the JLCT raised his personal views. He hoped that the boards of review can deal with more tax appeals. I fully agree with him. Yes, our tax law and system is much simpler compared with other jurisdictions, but I disagree that we have less taxation cases to deal with. Some cases might be against the decision by the Commissioner for Inland Revenue. And we see a rising trend when it comes to the number of appeals brought before the board. I think this will assist the board and also the legal sector to accumulate case laws and also different viewpoints. And the Board of Review prepares a report or booklets on an annual basis to help us to review the IR ordinance and in making tax assessments. Thank you. Thank you. Mr. Oleneksky, do members have any questions for Mr. Oleneksky or the administration? Mr. Sin Chung Kai. Now, regarding costs. Well, you require leave to appeal under the bill. And if leave is granted and the appellant subsequently loses the case, will he have to pay the costs of the other party? And what about the cost for hearing on leave to appeal? Whenever there is a hearing to deal with litigation, now, if the court rules against the appellant, then the latter will have to foot the bill or they pay the legal costs. Now, the judiciary proposed that it is not necessary to conduct a formal hearing to consider leave to appeal. A decision can be made by documents, by document reviews. If the appellant feels aggrieved and wants a proper hearing for the application, there is such a flexibility in the law, a formal hearing can be held. Thank you. Further question, Mr. Sin Chung Kai? Not for the time being. Any other questions from members? Under the current system, case stated procedure and the new procedures proposed in the bill, what are the basis for saying that the new arrangement will be more efficient? Because according to Mr. Oleneksky, you have raised the threshold. So I don't think this is a progress compared with the previous case stated system. Do you think you can really save time using the new appeal mechanism proposed in the bill? Chairman, if I may. Regarding a stated case procedure, we require the appellant to go to the Board of Review when he wants to appeal against a decision, and the board has to require the appellant to give grounds for his appeal, and different parties will be required to advance justifications. So the board will have to deal with dozens of appeals on an annual basis, and given is limited time available to the board, it has to fix dates for hearings for these appeals. So you can imagine the constraint, the manpower and time constraint, and that could lead to major delays in dealing with appeals. And the court has pointed out that this is very different from other jurisdictions such as the UK and Australia. They deal with complaints directly by the court. This stated case procedure will prolong the time for dealing with appeals, and it will also unnecessarily affect the efficiency of the board in dealing with other tax appeal cases. So we believe we must improve the system. Now, instead of the case stated procedure, appeals will be laid before the court, and leave of appeal is required. That will mean some manpower implications on the court. However, the judiciary has proposed that leave to appeal can be considered in writing, and a hearing will only be conducted upon request by any party. So this is a flexible arrangement which will help to expedite the whole process. Mr. Olenecky.
In your knowledge, maybe, I'm just asking a very general questions. I'm just trying to compare the appeal system from the Board of Review here in Hong Kong with maybe an Australian system, or even the UK system, whereby an appeal from the Special Commissioner to the High Court. Is there any threshold similar to what is stated in this draft bill here, is required, for example, under the appeal system in Australia, or when a taxpayer appeal from a decision of the Special Commissioner in the UK? Are you aware of anything, or can you provide us with any, information about that?
Mr. Chairman, I'm embarrassed to say this, but I don't know the answer to that. I can find out if you wish and relay that information, but offhand, no.
Okay, if you can, please make an additional submission. 各位委員仲有冇
Further questions from members? Well, apart from Mr. Sin Chung Kai.
I guess if since the appeal has already had a threshold, that is, if defeated, the appeal persons will have to pay the proceeds of the court, and well, that has already a deterrent effect for any grieved persons to appeal. And if since the proposed system by the government requiring a permit, right, or a
how do you say approval?
Would that be actually a double burden for the grieved persons?
Mr. Olenecky, and then maybe the government.
Yes, well, the current procedure is that you apply to the board to state a case, and the board does have a hearing, or it may do that on the papers as well if there's no objection. That's the usual procedure. If you have to apply for leave from the court, it's not an automatic right as currently exists under the board. And again, that may be on the paper, so we're transferring the responsibility from the Board of Review to the court. But in terms of costs and disincentive, the costs before the board are borne by each party. The board, each party bears their own costs before the board in making the application. If, however, the decision, the leave application is made to the court, then at the end of the day, the person who loses will bear that cost of both parties. So it actually will be more expensive for litigants, for the losing litigant, under this court procedure.
我想問多個問題。
One further question for the administration. If the court of first instance doesn't give leave, I'd like to know whether this decision is appellable. Yes, it is appellable to the Court of Appeal. Any further questions, Mr. Sin? Apart from the submission from JLCT, we have got submissions from the Certified Public Accountants, Hong Kong Bar Association, as well as the Law Society. Please refer to papers CB1 1204/1415 bracket 02, 03, and 04 respectively. The bar has proposed some textual amendments. Apart from that, I think the three organizations have presented quite similar views to us. Administration, please respond. Yes, we have prepared a consolidated response to these organizations in a table already submitted to the Secretariat. Regarding the proposed requirement for applying to the CFI for leave, well, the JLTS, STN, also the CPA and also the Law Society have some reservations, but the Bar Association does support that. All these organizations have expressed reservations and comments on the threshold, and I think we've already talked about our views. And apart from views on requirement to apply for leave of appeal, I note that the CPA have expressed some views on the composition of Board of Hearings. I think they want some experts to form full-time committees so as to deal with more complicated cases. So we have noted this view from the Hong Kong Institute of Certified Public Accountants. Indeed, in the past 5 years, the number of cases dealt with by the board had fallen from 112 cases to 40 to 50 cases per year. So we've increased the number of members, and the number of deputy chairmen has been increased from 5 to 8, and honorary members from 50 odd to 60 odd.
We believe the workload is manageable. So at the present moment, we don't see a need to change the composition of the board. We also note the comment made by the Hong Kong Bar Association concerning the proposed ceiling of cost. And in setting costs, in respect of setting costs, we would facilitate or make it possible for the board to award higher costs to deal with cases of frivolous appeals. Hong Kong Bar Association also proposed some textual amendments, and we have provided detailed response. We would like to propose that when we proceed to cross-examination, those points can be raised, and then our response can be put forward for members' consideration. That would facilitate focusing on the salient points of the bill. You said the Hong Kong BA Bar Association supports the leave threshold. Can you pinpoint which paragraph is it in the Bar Association's program? In a submission, paragraph 4 is relevant, but where can you find that in the paragraph? Well, I think the Bar Association supports the requirement of leave, but for leave threshold, the Bar Association's view is the same as the other deputations. All right, members, any questions concerning the 3 submissions? If not, then I'd like to thank Mr. Olenitsky for your valuable time, and I await your additional information. We now continue with our scrutiny with the administration. So, Mr. Olenitsky, you're free to leave now. At the meeting of the 7th of July, members raised some points and for which a response has been provided by the administration. It's a CP 11204/1415/07. Allow now to invite the Deputy Secretary to walk us through this paper from the administration. Thank you, Chairman. Actually, there are 2 major points. At the last meeting, I believe it's Mr. Sin Chung Kai who asked questions about statistics of tax appeal cases. And also when such cases are considered, how many cases are successful and how many are not. The relevant statistics and where there were further appeals by way of the case-stated procedure, we have set out the relevant figures on page 2 of our paper. Secondly, some members asked us to elaborate on the question of that the Board of Review is the final adjudicator of matters of fact. And why is it that when an appeal is lodged to the court on the point of law, no additional information can be submitted in support of the appeal, and the reason for that? Yeah, actually, the Board of Review is the final arbiter of matters of fact. And to maintain the same procedure, we would stipulate in the bill that the court will only handle appeal against the board's decision on a question of law, and no additional information on facts will be admissible. But if there are questions concerning matters of fact, the case can be returned to the Board of Review so that it can consider afresh matters of fact. I believe this would be the right balance and can address members' concern. And it will not affect the functions and duties of the Board of Review in the bill. Members, any questions on this paper from the administration? Deputy Secretary, on the second page of the paper, you have listed out the success rate in the first table of appeals. Most of the time, in most cases, the Inland Revenue Department won the cases. And then in the second table, is about cases of appeal in the court of first instance. So there weren't many from 2010 to 2015. For annually speaking, is 1 to 8 cases. As Honest Nikki said, is there really a need to have this threshold, a reasonable prospect of a suspect that you have to put this in the law? And because even without this threshold, the court of first instance would exercise its discretion and consider whether the appeal should be heard. It doesn't really make a difference. That's what I'm saying. Annually, through the case-stated procedure, we are seeing the fluctuations. If we look at the past 10 years, you can see that the number fluctuated. On the question of appeal threshold, we cannot just look at cases involving the board's decision. The court has to consider appeals from other boards and other tribunals, as well as from cases from inferior courts. So there are many cases where leave requirements is required. And the court has commented that for appeals requiring leave, the matter of threshold must be considered. The factor of threshold must be considered. We are just making this explicit in the bill. Well, I was just pointed out whether this is just some personal comment from a judge or a magistrate or tribunal officer. So did you ask the judiciary to confirm the way the bill is drafted, or did they ask you to do this? Well, actually, it's a request from the judiciary. Any other questions on the policy in the bill, members? If not, we will now proceed to cross-examination. I would like to scrutinize both the Chinese and English texts. In doing this, we'll be looking at both versions. Deputy Secretary or Mr. Poon? Thank you, Chairman. Clause 1, short title of the bill and commencement. This ordinance comes into operation on the day to be appointed by the Secretary for Financial Services and the Treasury. That's clause 1. If you have questions, by all means raise your hand to let me know. Clause 2, Inland Revenue Ordinance amended. The bill amends the Inland Revenue Ordinance as set out in sections 3 to 14 in the bill. Clause 3, Section 65 of Inland Revenue Ordinance is amended. This is about the constitution of the Board of Review. It is mainly about the wording. When the full title of the Board of Review and when the abbreviation the board will be used. There are some amendments. And in Chinese, a certain case is called Mao Zhong, and now it's called Mao Hong. It's something about drafting. Bracket 3 is about Section 65(7)(b). Ms. Sito, please switch on your mic.
某項啊，咁其實過去大家講某宗個案幾多宗個案，連政府自己啲文件都係講幾多宗個案嘅喎。
Well, we talk about the number of cases in Chinese as a 某宗. A certain case is called 某宗個案 in Chinese, not 某項. So why do you want to make the change? Thank you for your question. Instead of 宗 in Chinese and we call it 項. Well, actually the subject is appeal. Under the Inland Revenue Ordinance, in other provisions, we use the term 項 in Chinese. And now it's not consistent. Sometimes an appeal is called 某項 or 某宗 in Chinese. So we just want to make it consistent. There are other sections which use 某項, 65, 67, 4, 5, and 68, 1, 2, 2A, and 3B, 2B. This is just for consistency's sake. This is not a legal question. It's a question of linguistic point. What about other ordinances, not just the Inland Revenue Ordinance? Do you use 宗 or 項 in Chinese? Do you have to make it consistent in all the ordinances? Well, if we are to do that, it's going to be a mammoth task. But if you just look at Inland Revenue Ordinance, when it comes to appeal, the Chinese term is 項. As for the difference between 宗 and 項 in Chinese, an appeal is 一宗. I would say that the term 項 in Chinese is used in a more generic sense. It has a wider application. If we talk about a case, meaning a 宗 means a case. If you talk about a case, it's the number of cases that you're talking about, but in that particular case, there are a number of matters under appeal, so you want to use the Chinese 項.
Thank you, Chairman. Well, we did not have the Chairman's consideration when we proposed this. We just want to achieve consistency, and we think that the word 宗 can adopt a wider sense. Ms. Sito, can we ask our legal advisor to consult our Chinese experts in the council and advise us on this later? Yes, please look up Chinese dictionaries and assist next time. And we look at clause 3, amending section 65, different subsections. I don't know what is the rationale behind this. Section 66, 65, for instance. You always use the Board of Review in the heading, and take subsection 2 as an example. You say there shall be a clerk to the Board of Review and thereafter, and you delete this definition. Perhaps this drafting method using hereinafter referred to as the board is rather dated. But for 65, you don't do the same. In section 66, for instance, you always use the word board. Well, when the term Board of Review appears for the first time, we want to use the full term, and then later on or thereafter it will be referred to as the board. In fact, there is a definition for the board in section 66. So every time the board appears, we rely on the interpretation in section 2. So in addition to the heading, you always use the word board in the text, and section 2 defines the term board. Is that right? I don't think so. If we take a look at 66(1)(b. Now I get your point, but take 65 as example. In the heading, you say Constitution of the Board of Review, and in subsection 1, 3, first group of words, you use Board of Review. Now, since you already used the full term Board of Review in the heading, why do you have to repeat the full term in the text? In 65(1), line 3, you repeat a Board of Review again. Since you already provide a definition for board in section 2, can you just use the word board here? The definition uses the full term Board of Review, and therefore whenever the term appears for the first time in a particular section, we have to use the full term. So the heading doesn't form part of the text. Yes, it is not part of the body. All right, I think I can get it, but I don't really agree. Clause 4 amends section 66 to add the word review of review to the text. Okay. Please go on. Clause 5, amending section 67. As pointed out or explained by the colleague from DFJ, whenever the term Board of Review appears for the first time in a particular section, we use the full term. And we also mentioned 14 working days. 14 clear days. We've changed that to 14 days because in other parts of the IRO, whenever there is reference to days or time, we always use a certain number of days instead of certain number of clear days. So for consistency's sake, we go for a certain number of days. Is there any technical difference when it comes to day and clear day? According to the Interpretation and General Clause Ordinance, whenever two dates are mentioned, then the two dates are exclusive. And so here there is no difference. We just want to delete the word clear to ensure consistency within the ordinance. Okay, clause 6. It amends section 68 of the IRO. The amendments are mainly to the Chinese text. 68. Subsection 1, or clause 6(1) refers to 68(1)(a). We believe the substitution is much better. It can reflect the meaning better, and so we are proposing to replace the Chinese text in this way. and subclause 268(1), section 68(1) again, we have deleted the word clear. The meaning remains unchanged. Any questions? Mr. Poon, please go on. For the remaining subclauses, it's also to the Chinese text. Under subclause 3, section 68(1) has got some of its words deleted. And I think it would be easier if we refer to the marked up copy. But the meaning is just the same. And subclauses 4 and 5 also amends the Chinese text of 68(1), section 68(1). There is no amendment to the English text. Subclause 5 amends the Chinese text of 68(1). Some words are deleted to ensure consistency. So you may appoint more than one, authorize more than one to attend a meeting. Is that correct? Yes, please. Thank you. Chairman, your understanding is correct. If members may refer to the English marked up copy, 68(2) says an authorized representative. And according to Cap 1, Interpretation in General Clauses Ordinance, a plural, a singular verb can cover the plural. And here it says an instead of one. If we use one, that means the exact number is one. But when we say an authorized representative, that means it can be one or more. So for consistency, we have to amend the Chinese text. We have to remove the Chinese word yat, meaning one. Yes, please go on. Subclause 7, to amend section 68(3), the Chinese text, once again. No change to the English text whatsoever. Yes, please go on. Subclause 8 amends section 68(10) to add subclause 11, subsection 11. It says, subject to section 69, the board's decision on the appeal is final. So this is about the finality of the board's decision. In current section 68(1), it is already mentioned that the decision by the board is final, but we have decided to move the subsection to the very end of section 68. So 69 is the provisions on appeals, right? Any questions, please? Mr. Poon, please go on. Clause 7 of the bill, to add two new provisions, namely 68 capital AAB and capital AA, 68AA. For 68AA is about directions on provision of documents and information by the board. Or perhaps I should go through the subsections one by one. All right, subsection 1. Without limiting section 68, the person who is to preside or is presiding at the hearing of an appeal under section 66 may give directions to both parties to comply with. And the presiding member or person is authorized to reject or to refuse to admit an evidence any document or information that is not provided in compliance with directions given under paragraph A. So if someone doesn't follow the directions of the presiding person, then he can be penalized or sanctioned. Legal advisor. Thank you. On the 14th of August, there is a letter sent to the administration, and there was a reply from the administration on 68 AA subsection 1. Now, under this provision, the presiding officer may give directions on the provision of documents. According to the reply by the administration, the current drafting may include directions that or documents to be covered, and according to administration, this is not a problem. They just want to tackle the problem of late submission of documents. So the directions here on provision of documents, maybe on the timing and also the mode for submission of documents, but the current drafting may cover a wider scope. Because under 68 AA1, it seems that all circumstances relating to the submission of documents can be governed. It is not confined to the time limit and the mode on provision of documents. Yes, we have to strike a balance here. On the one hand, we want to give the board sufficient powers in dealing with hearings. We hope that the board can be empowered to require the submission of documents. However, we don't want the clause to be too narrow. If we specify the type of information documents here, well, this is not what we want to do. Now, if either party has evidence to submit, he may do so. So the understanding of documents here is rather wide in scope. We do not dictate the type of documents to be provided. Any further questions? Subsection 2. If the presiding person decides to exercise the power to refuse to admit in evidence any document or information, the presiding person must, as soon as practicable after making the decision, by notice and writing given to the party. This is to ensure transparency.
Mr. Poon, the purpose of 68 AA is that if you submit documents late, the presiding officer, the board, can refuse to admit it, but there's no penalty. The worst that can happen is the refusal to accept the document. Is that correct? Yes. If the document is not admitted in evidence, it's a decision of the presiding person. It can be a chairman or one of the deputy chairmen. And there are other provisions. If certain information is refused admittance, then certain things can happen. The defaulting party can ask for the relief within 14 days. That's dealt with in subsections 4 to 6. The presiding officer must consider the relevant circumstances And in subsection 5, the presiding officers must, as soon as practicable after determining the application for relief, notify the defaulting party. And also in subsection 6, it sets out the factors to be considered by the presiding officer. Legal advisor concerning 60AA bracket 6 bracket E. That's covered in my letter to the administration, and I would like to let members know that in bracket 6 bracket E, it provides that the presiding officer may consider the extent to which the defaulting party has complied with other direction of the presiding person. It covers the language and other manners of submission. Well, if a document is submitted late and is refused submission, the departing party can ask the presiding officer to reconsider the admission of the document. Then, is that a separate hearing, or is it done something? Is this something done through written submissions? What kind of format would it take? In 68AA bracket 4, we can see that the application for relief may be determined without a hearing. Is it going to be considered by the same presiding person? Correct. Mr. Poon, if I may, I would like to inform members that in respect of this provision, the Bar Association has raised something about the wording. They want to have some loose wording. Don't be so specific. Don't just talk about documents or information. And they propose that the presiding officer, in exercising his powers, may give orders or directions. Well, we do not want to give the presiding officer general powers like this. We want to make it specific that he can make a decision on the admission of documents or information. We think that the Bar Association's proposal is too wide and general. That would not be in the interest of the appellant. Members' questions? Legal advisor? Chairman, you mentioned that in accordance with 68AA, this is mentioned in the letter. And that is, I raised the question of whether under subsection 3, if an application for relief is made, is it required to be made in certain manner or format? According to the administration, there's no fixed format. 68AA bracket 6 provides for some detailed procedures. Have you consulted the judiciary and all the chairmen of the Board of Review? How have you arrived at the details? Well, we are providing the procedures similar to the High Court rules. 68AA, any questions? Mr. Poon, please continue. 68AAB, privileges and immunities for parties involved in the hearing. At present, under the IRO, the chairman or deputy chairman or member of the panel are not provided with any privileges or immunities. And likewise, those attending the hearing are not protected by any privileges or immunities. So we'll make reference to the same privileges and immunities for the judge in the course of first instance in civil proceedings. So the chairman, the deputy chairman, or any other member of the panel, or a witness, or counsel, or solicitor, or person representing a party appearing before the board would enjoy the same privileges and immunities in civil proceedings in the court of first instance. This should ensure fairness and justice. Who will be covered? Apart from chairman of the board of review and the members, 3 of them. Who else?
3款嗰度咧，我哋就講咗係有啲乜嘢嘅。
Well, you can please refer to bracket 3, who would also enjoy the privileges and immunities. A party to a hearing before the board of review, or a witness, counsel, solicitor, or person representing a party appearing before the court. That is to say, everyone who appears before the board of review. That means everyone. Correct. Everyone appearing before the board. Correct. Members, questions? Any questions? Section 69. An important provision. Mr. Poon, please introduce this clause. At present, in the IRO, appeal against the Board of Review's decision is Section 69 by way of a case stated. And we want to replace this with a leave requirement provision. So Section 69 is to be repealed, to be replaced by a new provision. For the new Section 69, if a party wants to launch an appeal on a point of law, the appeal can be launched with the court of first instance. That's in bracket 1. Please continue. Bracket 2. The appellant has to satisfy certain conditions before an appeal is allowed to be heard. First, the court of first instance must make a determination for which leave has been granted. That is to say, an appeal can only be lodged with leave. 2A, court of first instance has granted a leave, and if there is a leapfrogging procedure to the court of appeal, then the leave from the court of first instance is also required. Correct. If the case is lost in the court of first instance, then another appeal can be lodged with the court of appeal. Is that correct?
9條第4款入邊咧所講嘅情況咧係如果原訟。
We are talking about the leave being denied by the court of first instance.
係，唔該。
好啊，跟住第69條嘅第3款咧就係向
Bracket 3. Procedure on the lodging an appeal. For example, the time limit to lodge and to submit an application to the court of first instance. And also the information to be included in the submission. And if the other party wants to lodge, to oppose the application, then it can also submit information to the court of first instance within 14 days. And the court of first instance can make a determination without hearing. And similarly, a hearing can be conducted. So the court is given the flexibility to deal with different kinds of appeals. 69, 3A, Roman 2, made by a summons. What kind of document is that?
都係 嗰個上訴人佢要提出上訴嘅時候
The appellant has to give some information to the court. So it's a summons in which certain information is required. A statement, for example, a statement to be provided by the appellant or prospective appellant setting out the grounds of the appeal. It's the same way as other leave application procedure, as it's done by a summons. And if it's about matters of law, then the grounds will have to be so stated in the summons. D, the court of first instance must inform the parties of the date of the fixed for the hearing. And then E, factors to be considered. First of all, Roman 1, that a question of law is involved. That's very obvious, as we have already discussed. An appeal can only be launched on a point of law, and the court of first instance must be satisfied that the appeal is on a point of law before leave is granted. Roman 2, the threshold, appeal threshold. And we have had a discussion on that already. E, bracket E, members, please continue. F, after leave is granted, then the dates and place of hearing will be the subject of a notice to the parties. G, as I have said, the court of first instance can make a determination on the basis of written submissions only. And under G, if any party is aggrieved by the written submissions, the party can ask the court of first instance to reconsider the determination within 7 days. Under E or F, do we have any requirement on how long the determination has to be made on the question of leave by the court of first instance? I don't think there's any time limit set here. No, in fact, no.
Any questions? No? Then Mr. Poon, please go on. H, a hearing held in response to a request may be before the judge who has determined the application on the basis of written submissions only. All right? Subsection 4. Now, if the court of first instance refuses to grant leave to appeal, what can the applicant do? He may consider making a further application to the Court of Appeal for leave to appeal against the board's decision. Subsection 5. For this kind of application to the Court of Appeal, the procedures are set out here. They're very close to the previous application. The timing and the documents required. And if the other party disagrees, how it may raise his ground of objection. Mr. Poon. Is A to H here identical to A to H in the previous subsection? Well, they are very close. Can you highlight the differences, please? C, because the Court of Appeal may have more than one judge, and therefore we have specified in C that the Court of Appeal may determine the application by means of one or more judges. When the applicant decides whether he should lodge an appeal to the Court of Appeal or Court of First Instance, I do not see anything here to dictate the court he should go to. Are there any requirements? Under subsection 69, we talk about lodging appeal to the Court of Appeal after the Court of First Instance has refused the application. My question is, or perhaps Ms. Lee can take this question, or the DOJ can let you know whether there is any way where the Court of First Instance can be bypassed. And is there any legal provisions on this? If I may try regarding frog leaping, well, 69A has provision on this. Now, we all talk about an application to the Court of First Instance first. If leave is not granted, then the applicant may lodge another appeal to the Court of First Instance. So it is a matter of sequence. I think will be clearer when we go to 69AA. Do we have any questions? If not, please go on. E to H is about the procedures for the Court of Appeal to consider, to take. So this is about the arrangement to apply for leave of appeal. Do we have any question on Clause 68? Mr. Poon, please go on. Section 69. AA. This is a new Clause 7. New 69AA. Clause 7 of the bill. This is appeal against Board of Review's decision, hearing of appeal. When the Court of First Instance has given leave of appeal, what are the legal provisions for the Court of First Instance to follow? In subsection 1, we say that the Court of First Instance may draw any inference of fact, may confirm, reduce, increase, or annul the assessment determined by the board, or may refer the matter back to the board and make any order as to costs. And the Court of First Instance must not receive any further evidence, and it must not reverse or vary any conclusion made by the board on questions of fact. This is to ensure the division of labor between the board and the Court of First Instance. The board has final say over the question of fact, and the court will only deal with question of law. In other tribunals, such as the Labor Tribunal and Small Claims Tribunal, there are similar arrangements regarding this division of labor. Mr. Poon, if there is a very important piece of evidence not submitted to the Board of Review, and the evidence, the piece of evidence, will have a determining value. So what can the court do? Because under 69AA, the court must not receive any further evidence. If both parties are of the view that the piece of evidence that has been omitted or left out or not submitted to the board, what can the court do? Now, it says here that the Court of First Instance may draw any inference of fact, or may increase, reduce, or vary the assessment. This is already found in the current clause, section 69. Regarding the part on the court of first instance not allowing to receive any further evidence. Now, if the piece of evidence is not submitted to the board at all and is considered important by all parties, well, we have cases in the past where the cases would be referred back to the board for consideration. So we say here that the matter may be remitted back to the board. So the court may confirm, reduce, increase, or annul the assessment. But if the court rules that the case is wrong on a question of law, it does have the power to overturn or vary the decision of the board. So we want to retain the roles and functions of the board, and we will also want to retain the board's power to allow an appellant to appeal against a decision of the board if it is found that there is something wrong on the questions of law or on other matters. 69AA subsection 2. If the court of first instance has made a determination on an appeal for which leave has been granted, and there is an appeal to the Court of Appeal against the court of first instance determination, then paragraphs A to B of subsection 1 applies to the Court of Appeal in hearing the appeal, as if references in those paragraphs to the Court of first instance were references to the Court of Appeal. Subsection 3, subject to subsection 2, the High Court ordinance applies to proceedings before the Court of Appeal under this section. Questions from members? Do we have questions from members? Okay, Mr. Poon, please go on. Thank you. Clause 10, amending Section 69A. Right to appeal directly to Court of Appeal against decision of Board of Review. Section 69A is about this arrangement. But since we have changed the case stated procedure to the requirement of leave to appeal, Section 69A has to be amended accordingly. Subsection 1 is deleted to be replaced by the following. Where leave to appeal has been granted under Section 69 in respect of a decision of the Board of Review, the appellant or the commissioner may appeal directly to the Court of Appeal against the Board's decision. However, there must be leave to appeal granted by the Court of Appeal first, and therefore to frog leap, then must be leave to appeal by the Court of first instance first. That means there are two steps to be taken. True. Excuse me. The Bar Association proposed that for this arrangement, for a leapfrog arrangement, there should be a time limit. For instance, a formal case must be put to the Court of Appeal within 1 month leave is granted. We have not included this in the bill, but the Bar Association would like to have this arrangement. When we consulted the judiciary, there was no mention of this 1 month restriction, because usually when there is a leapfrog arrangement, the appellant must be rather anxious as well. So unless members insist, we don't intend to add this time limit. Do members have questions? Yes, the appellant should be eager to do it, but if it cannot beat the deadline, I don't think we should put any restriction here. And the judiciary has not made such a request. Under 69A2, we have already got this condition, and we have no intention to make major arrangement to this. Leave to appeal on the ground that, in the opinion of the Court of Appeal, it is desirable that by reason of the amount of tax in dispute or of the general public importance of the matter or its extraordinary difficulty, or for any other reason, the appeal be heard and determined by the Court of Appeal instead of the Court of First Instance. This will stay. Yes? When the Court of Appeal considers a case under leapfrog arrangement, the court must not may draw any inference of fact and may confirm, reduce, increase, or annul the assessment determined by the board, or remit the matter back to the board. Subsection 4. In addition to the conditions mentioned above, the High Court ordinance applies to proceedings before the Court of Appeal under this section. Thank you. Any questions, please, members? Mr. Boone, please go on to Section 82B, Clause 11 of the bill, amending Section 82B of the ordinance. 82B is about appeals against assessment to additional tax to Board of Review, because Section 82B provides a channel for a taxpayer to lodge an appeal against additional tax. 82B, the amendments here are textual in nature. For instance, for the word board, we add of review to it, and also some textual amendments to the number of sections.
Legal advisor, you have a question? Again, in the letter previously sent to the letter, there was a question on 82 capital A bracket 3. It states that in Cap 112, in some of the provisions, there are provisions on appeal against assessment of other tax other than additional tax. They would be applicable, but two are left out. Two are not applied, not applicable. Please refer to page 19 of the markup copy. 69 capital A is one of them. It's about hearing of appeal, a provision on hearing of appeal. The second provision that is not covered is page 20. That is a leapfrog arrangement, taking the appeal to the Court of Appeal direct. If members refer to pages 19 and 20 in 69AA bracket 1 and 69A bracket 1, they both state that where leave to appeal has been granted under 69, then certain provisions would apply. So in under is covered 69A is covered by this one on 82B. So my question is why these two appeal-related provisions are not applicable. In 69AA and 69 capital A, the former is about appeal against Board of Review's decision hearing of appeal, and 69 capital A is about the leapfrog arrangement, the revised arrangement for leapfrog arrangement. Both are not related to the procedure on appeal against the assessment. As the legal advisor has said, under 69AA, 69A, there are certain procedures to follow after leave has been granted under Section 69. So whether it's additional tax or other taxes, at this stage, leave has already been granted. Whether you talk about one type of tax or another tax. So in next 82B, there's no need to mention the two sections because leave has already been granted. Well, Orlans Nicky's submission mentions the nature of additional tax, which is like a fine, criminal fine. And the appeal, the threshold should not apply to the assessment of additional tax, because if it's a criminal case, then there must be a threshold, whether it's additional tax or other kinds of tax. They are all subject to the case stated procedure in the current ordinance. And now we want to enhance the efficiency and introduce a leave requirement. We believe it should apply to all types of appeals, including the cases involving tax, additional tax. Legal advisor. Thank you, Chairman. I want to say something about the administration's response. If these two provisions are not covered by the one on additional tax, and that is an appeal against assessment to additional tax will not be applicable under the leapfrog arrangement, and also 69AA, and the restrictions of not receiving any further evidence and not to reverse or vary any conclusion, the same effect will be applied to additional tax. Any supplement from the government? The legal advisor has referred to Section 69AA and the revised or amended Section 69A. They both have to do with the court of the hearing after the court of first instance has handled the leave requirement. And 69A is about the leapfrog arrangement. Section 69 will still be covered by the new section, or the amended Section 82B. Cases involving additional tax and other taxes will be handled by the court of first instance. 69AA and 69A are about court procedures. So we do not cover the application of these two provisions in Section 82B. When an appellant appeals against assessment to either additional tax or additional tax the leave requirement and the leapfrog arrangements would apply in the same way. 82B is about the procedure for an appeal against assessment of additional tax to Board of Review. 69 is connected to 69A, so there's no need to refer to it. In 82B, any further question from you, legal advisor? Well, if in this section no reference is made to the two sections concerned and still is applicable, then I think members should be informed. 82B is similar to the procedure in 68. '68 is about appeals not related to assessment to additional tax. We have a look at other provisions. If there's an appeal against an assessment, then you can link 68 to 69. 69 is about a leave requirement, and then during the hearing, the 69AA is applicable, and also under 69A there's the leapfrog arrangement, and under 82B bracket 3, all these are applicable to additional tax, but 69A and 69AA are not applicable. So in effect, since you do not mention 69A and 69AA, the two provisions will not be applied in the case of additional tax. Well, I can supplement some information. Well, I think you can explain in a flow chart to facilitate our understanding and the understanding of the legal advisor. I understand the legislative intent, but very clear, it can be explained by a flow chart on the relationship of these 3 or 4 sections. And to make sure that we have the coverage we intend. Mr. Poon, Section 89, I suppose, Clause 12. Let's look at this together with Clause 14. It's about amendment of Section 89 and Schedule 5. These are transitional provisions. If this bill is passed by LegCo and before the commencement date, the appeals lodged before the commencement date, they will be handled in accordance with existing provisions. And only cases or appeals lodged after the commencement date will be handled under the new amended procedure. This is to ensure certainty. Why is it that? Let me see.
或者你可唔可以補充下究竟個
You can explain a little bit about how come there are so many transitional provisions? Let's look at the Schedule 35. If an appeal is lodged before the commencement date of the new bill, in accordance with the existing Section 69, and it has been formally submitted, and that for this case, even after the commencement date, the appeal will be handled according to the existing provisions. So there will not be a situation whereby in the first part of the appeal procedure, it will be handled under the old provision and the latter half under the new provisions. If the appeal is lodged after the commencement date, then the new procedure, the new provisions apply. We can therefore avoid well, these are existing provisions. It has got nothing to do with the amendments. Do you look at the date the appeal is drafted or the date the board received the application? How do you determine whether a bill is made or lodged before commencement date? I think we are talking about an appeal made and submitted to the Board of Review before the commencement date. So the date of it is we look at the date of receipt by the court, by the Board of Review. Correct. Is it actual or constructive receipt? If it's laid on the table of the clerk, or is it that we look at the date of sending out the application? Well, in Schedule 35, under the existing, we talk about an application delivered under the existing Section 69. Then it will be handled in a way as if there's no new bill. Members, any question on Schedule 35? Legal advisor? I don't have questions. Generally speaking,
information 我亦都等緊JLCT 嘅 chair.
All right, so we'll await further information from the administration and certain additional information from JLCT. Actually, we have yet to discuss clause 13. It's about amendment of Schedule 5. At present, the board can award costs with a ceiling. The current ceiling is $5,000. That was set in the early 90s, has remained the same since, to better deter frivolous tax appeals. We propose an increase of the ceiling to $25,000.
意見書
The bar's submission supported this proposal. How did you fix it at 25,000? What is the justification? When we discussed policies last time, well, we said that the current cost ceiling was $5,000, and of course, for most of the cases, no costs have been awarded. But when there is a real, really frivolous appeal, then the board might award close to $3,000. So many years have elapsed, so we believe $5,000 is no longer sufficient deterrent. And to consider the cost, for each case is as much as 80,000, but of course we do not want to increase it so sharply in one go. So we have decided to increase it by 5 times to 25,000. We have consulted the judiciary and JRST, and they all agree that this is an acceptable level, and we will closely monitor the deterrent effect of the new ceiling. All right. Do we have further questions on this bill? So we've completed clause-by-clause scrutiny of the bill, and we still have additional information papers pending. I'd like to know whether there will be CSAs from the administration. We have no intention to submit CSAs. What about members? Well, I have to wait before I received the submission from chairman of JLCT JLCT before I can say whether members or the BC has any CSAs. Right, since members of the BC and members will not move CSAs, I have two proposals for resumption of second reading debate of the bill. The first proposal is the 28th of October. If we intend to do that, then the deadline for submitting a report to this House Committee is the 9th of October. And the deadline for giving notice of CSA is the 17th of October. So that's the first option. Alternatively, if we want the second reading debate to be resumed on the 4th of November, that is 1 week after the first proposal, the deadline for submitting a report to the HC is the 23rd of October, and the deadline for giving notice of amendment is the 26th of October. So the program will depends on the administration and also arrangements by the BC. Both dates are feasible. I thank members and the administration for attending the meeting. If we still have other issues related to the bill, I hope we will be able to address them by circulation of papers. The meeting is now adjourned. Thank you very much.